Well, after 16 days of intense arguments before the Supreme Court Constitution Bench led by Chief Justice of India D.Y. Chandrachud, Supreme Court has now reserved its judgment in the batch of petitions challenging the constitutional validity of abrogation of Article 370 of the Indian Constitution. Well, last time we had done a recap of the 5 major arguments put forth by the petitioners. Today we are going to cut down as to what were the crucial points argued by the Government of India in support of the abrogation of Article 370. The first argument is accession to India was similar for all princely states. The Government of India has argued that contrary to popular belief, Jammu and Kashmir did not have a special status from the very beginning, and the draft accession agreement was same for all the princely states. The second argument is the abrogation has been beneficial for the people of Jammu and Kashmir. It has been argued that the psychological duality present in the state of Jammu and Kashmir ended with the abrogation of Article 370, resulting in a large number of people getting their fundamental rights. The third argument put forth by the central government is that Article 370 was not a privilege that it could not have been taken away. It has been argued by the central government that Article 370 is a self-extinguishing provision. It has also been put forth that any word which became OTOs in Article 370 used to be replaced. For example, the word Sadar-e-Riyasat was replaced by the term governor. Next, the Government of India argued that the abrogation was necessary to counter the situation prevailing in Jammu and Kashmir. It has been argued that the nation especially has been facing since decades a militancy, a rise in terrorism, etc. in the area of Jammu and Kashmir, especially since a part of Jammu and Kashmir is still occupied by Pakistan and is known as Pakistan occupied Kashmir. It has been argued that the decision to abrogate Article 370 was not a knee-jerk reaction and was in fact a well thought out policy consideration. The Government of India has argued that the decision to abrogate Article 370 could have been very well taken during the President's rule. The petitioners had argued that this particular decision, or this irreversible decision to abrogate Article 370, could not have been taken especially without taking resort to Article 368 of the Indian Constitution. However, the central government has argued that if the purpose of Article 370 was to enable a complete integration of Jammu and Kashmir or into the Indian Union, then that particular purpose was over. It has further been argued that nothing stops the President to take the stock of the situation as it exists under Article 370's Clause 1, Subclause D. It has also been argued that the Article 370 was incorporated for a specific period of time, and that period of time has now come to an end. Well, it has been argued by the Government of India that this particular abrogation of Article 370 is not violative of federalism. It has been submitted that federalism is a part of the basic structure doctrine and federal diversity can still exist within federalism. It has been stated that Article 370 has no place in the Indian Federation, and if Article 370 Subclause 1 is allowed to be made permanent, then it will make an unconstitutional provision remain in the Constitution of India. The next argument by the central government is that the basic structure doctrine cannot be applied in this case. It has been argued that only constitutional amendments can be tested on the touchstone of the basic structure doctrine. It has been submitted that there are no such constitutional amendments in this case, and thus the law bifurcating Jammu and Kashmir into the 2 union territories cannot be tested against the basic structure doctrine. Well, lastly, the Government of India has argued that the full statehood would be restored to Jammu and Kashmir very soon. Well, the Chief Justice of India D.Y. Chandrachud had posed a pointed question to Solicitor General Tushar Mehta and Attorney General R. Venkataramani to make a statement if at all the central government plans to restore full statehood to Jammu and Kashmir, to which Solicitor General made a statement that indeed a full statehood would be granted to Jammu and Kashmir as soon as normalcy resumes in the valley. And this entire exercise of converting it into a union territory was a temporary measure. However, there are no fixed timelines that have been submitted by the Government of India as to when Jammu and Kashmir would be restored back to the status of full statehood. It has also been submitted and clarified that Ladakh would not be granted a full statehood, and it would continue to become or to be a union territory. Well, these were the crucial points argued by the Government of India in support of the abrogation of Article 370. Now, all eyes are on the Supreme Court Constitution Bench for the verdict in this particular case. And stay tuned to Bar and Bench for all latest updates. Thank you.
Subscribe to our YouTube channel and click the bell icon.